I would now like to invite the delegation of Jordan, and I call upon Professor Marcello Cohen to make his presentation. Mr. President, members of the court, it is an honor to appear before you on behalf of the Hashemite Kingdom of Jordan and to reiterate its written statement and conclusions in which we list all of Israel's obligations that are the subject of this request for an advisory opinion. Jordan is particularly concerned by the issues under discussion here. The Hashemite Kingdom hosts 2,400,000 Palestinian refugees registered with UNRWA on its territory. It is the custodian of the Muslim and Christian holy sites in Jerusalem and is at the forefront of providing humanitarian assistance to the population of the Occupied Palestinian Territory. Jordan maintains diplomatic relations with both the State of Israel and the State of Palestine and works tirelessly for peace in the Middle East. Since the submission of the written statements, the situation has worsened dramatically as a result of the breakdown of the ceasefire, the ban on humanitarian assistance to Gaza, and Israel's actions in the West Bank. Hence the importance and urgency of this advisory opinion. I will briefly address the question of the exercise of advisory jurisdiction by your court, and then I will examine the impact of the principle of self-determination on the various aspects of the question posed by the General Assembly. My colleagues, Eric Bjorge and Alfredo Crissato, will address United Nations law and humanitarian assistance, respectively. Mr. President, there are decisive reasons for the court to exercise its advisory jurisdiction. The United Nations has a permanent responsibility with regard to the Palestinian issue until all its aspects have been settled in accordance with international law. The arguments put forth against the exercise of your jurisdiction are unfounded, namely that there is a risk of prejudging the outcome of a pending dispute. Secondly, that the question has already been dealt with by the court in its 2024 advisory opinion. 3, that the question is one-sided and hence would not take the context into consideration. Fourth argument, that the court would not have the necessary factual information. It suffices to say here that the case of South Africa versus Israel concerns exclusively the Genocide Convention, whereas the question raised in the present instance relates to Israel's obligations in a more general context. The question also differs from those already answered by the court in 2024. Last year's advisory opinion provided valuable legal elements to better answer the question now put to the court. It is a question which was not raised by the General Assembly in its previous request. Indeed, the question refers solely to Israel's obligations because it is Israel and no other state which occupies the Palestinian territory. The question asked is limited in scope. It does not seek to address all issues related to the persistence of the occupation or the situation arising from the 7th of October 2023. The General Assembly, like the Security Council and your own court, has already demanded the immediate and unconditional release of the hostages held in Gaza. This situation does not relieve Israel of its obligations under international law. Furthermore, the question posed concerns legal obligations, and the court has the necessary factual elements that would enable it to rule on them. If Israel has grievances against the United Nations or its organs, the Convention on the Privileges and Immunities of the United Nations provides it with the necessary means to take action. Mr. President, members of the Court, the principle of self-determination is of paramount importance in responding to each of the elements of the question posed. Indeed, respect for the implementation of this right by the Palestinian people is the backdrop against which all other obligations incumbent on Israel must be interpreted and applied. It further requires Israel, in the current circumstances and in accordance with its obligation, not to impede the realization of this right and to take all necessary and effective measures to protect the Palestinian civilian population. As self-determination is a fundamental principle of international law, a right erga omnes, and a peremptory norm of international law, Israel's obligations are not only towards the Palestinian people, but also towards the United Nations competencies in this matter and towards the international community as a whole. As stated in Article 1 of both the Human Rights Covenants, and I quote, "In no case may a people be deprived of its own means of subsistence," unquote. Israel's obligation to respect the Palestinian people's right to self-determination is without exception. The powers granted to Israel as an occupying power under the Hague Regulations and the Fourth Geneva Convention cannot be exercised to the detriment of the peremptory right of self-determination. In case of armed conflict, only the rules relating to the protection of human beings have been considered by your court as peremptory principles of customary international law, and the occupying power must respect them. As the court has affirmed, the powers granted to the occupying power are for a temporary occupation, not for an extended occupation, which constitutes a de facto permanent annexation in violation of the principle of self-determination. Israel has an obligation to cooperate with the United Nations, other international organizations, and third states to bring to an end its illegal presence in the occupied Palestinian territory as soon as possible in order to enable the Palestinian people to fully enjoy their right to self-determination, to seize all activities that prevent the exercise of that right, and to act positively to facilitate it. This includes the obligation to respect its territorial integrity, preventing any form of displacement of its components and refraining from any change in the demographic composition of the territory, and ensuring and facilitating the unhindered provision of emergency supplies essential for the survival of the civilian population, as well as the provision of basic services and humanitarian and development assistance. Israel also has an obligation to respect the permanent sovereignty of the Palestinian people over their natural wealth and resources, and not to impede the diplomatic, consular, and other relations of third parties and international organizations with the Palestinian authorities. The Knesset adopted a declaration stating that it opposed the establishment of a Palestinian state, and it did so just a day before your court issued its advisory opinion in July 2024. This declaration by the Israeli parliament is once again in flagrant contradiction with the right of the Palestinian people to self-determination. All organs of the State of Israel have an obligation to respect this right and not to obstruct the exercise of this right. In this sense, there is an obligation to repeal any legislative or administrative provision aimed at preventing the realization of the right to self-determination. Mr. President, members of the Court, there is no justification for the continuation of the Israeli occupation of the Palestinian people, which prevents them from exercising their right to self-determination. The first relevant obligation is therefore to respect that right and to seize its violation. It is only through strict respect for international law and not through expansionism or oppression or force that problems can be solved. The best guarantee for peace in the entire Middle East is a two-state solution that respects the independence and security of both states. Thank you for your attention, Mr. President. I now request you to give the floor to Professor Eric Bjork.
Je remercie le Professor Cohen. I now invite Professor Eric Bjork to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of Jordan to address Israel's obligations under the law of the United Nations. I make 4 points. First, Israel's obligation to respect the privileges and immunities of the United Nations. Second, Israel's obligation to give the United Nations every assistance. Third, Israel's obligation to cooperate with other states. And fourth, Israel's obligations regarding the safety and security of United Nations personnel. First, Israel has an obligation to respect the privileges and immunities of the United Nations. Israel recognized in the exchange of letters with UNRWA of 1967 that a number of facilities were essential for the agency to operate effectively. The fact that Israel recognized these facilities as essential indicates that they are, pursuant to Article 105 of the Charter, necessary for the fulfillment of UNRWA's purposes. The General Assembly has recalled that the agency, as a subsidiary organ of the United Nations, enjoys the benefits of the Convention on the Privileges and Immunities of the United Nations. The main provisions of the General Convention anyway reflect customary international law. I will deal with 3 of these. The immunity from every form of legal process set forth in Section 2 is essential for the independent exercise by UNRWA of its functions. The inviolability of UNRWA premises set forth in Section 3 guarantees that the premises may not be entered and that the United Nations must itself be permitted to control activities occurring on those premises. All UNRWA officials enjoy immunity and the privileges set forth in Section 18. The provisions relating to officials in the General Convention apply to all staff members, the only exception being those recruited locally and assigned to hourly rates. Those criteria are cumulative. The immunity of UNRWA from every form of legal process and the inviolability of its premises are absolute. They may not be qualified or overridden by military expediency or national security. Israel has an absolute obligation to respect the privileges and immunities of the United Nations. Israel self-evidently has an obligation, inter alia, not to enter UNRWA premises, not to damage or destroy such premises, not to detain UNRWA staff without charge or trial, and not to seek to extirpate the agency from the occupied Palestinian territory. Second, the text of Article 2, Paragraph 5 of the Charter is to the effect that Israel has a general obligation to give every assistance to the United Nations. State practice, including that of Israel itself, confirms this. The contention by Israel that the obligation relates only to enforcement action taken by the Security Council has no basis in international law. The interpretation for which Israel now contends runs counter to the clear wording of Article 2.5 and is inconsistent with the court's interpretation in the reparations case. Israel has an obligation to give UNRWA every assistance in any action it takes pursuant to the provisions of the Charter. There is a further aspect. Judge Lauterpacht was correct in voting procedure, where he observed that a state which ignores a series of General Assembly resolutions acts at its peril when a point is reached, when the cumulative effect of the persistent disregard of the articulate opinion of the organization is such as to foster the conviction that the state in question has become guilty of disloyalty to the principles and purposes of the Charter. Israel is obliged to give the Charter, Israel is obliged under the Charter to give due consideration in good faith to the resolutions of the General Assembly. In whaling in the Antarctic, the court adopted this reasoning in respect of the Whaling Convention. It applies no less to the Charter. Israel has the obligation to give due regard to General Assembly resolutions, notably those adopted in the 10th Emergency Special Session. Third, one of the purposes of the United Nations is, according to Article 1, paragraph 3 of the Charter, to achieve international cooperation in solving international problems of a humanitarian character. As Judge El Arian observed, the principle of international cooperation in Article 1, paragraph 3, is, like the other purposes and principles of the United Nations, a legal principle, binding on states. The Charter recognizes this in Article 14, to which the court was taken this morning, and which addresses the situation of, I quote, a violation of the provisions of the present Charter, setting forth the purposes and principles of the United Nations. End of quote. This obligation to cooperate was developed in greater detail in the Friendly Relations Declaration. Its fourth principle lays down the duty of states to cooperate with one another in accordance with the Charter. Fourth, Israel's obligations as regards the safety and security of United Nations personnel. Israel has obligations in this regard under the rules of customary international law codified in the Convention on the Safety of United Nations and associated personnel. That this convention codifies customary international law is evident from the fact that the General Assembly adopted it by consensus. Notable in this regard is Israel's obligation to facilitate the unimpeded transit of UNRWA and other United Nations personnel across its own territory. This obligation includes unimpeded transit from one part of the Occupied Palestinian Territory to another. Israel also has the obligation to ensure the safety and security of United Nations personnel, to release detained personnel, and to penalize crimes against them. Israel has, finally, the obligation not to make UNRWA or other United Nations personnel the object of an attack or any other action that prevents them from discharging their mandate. That, Mr. President, members of the Court, concludes my presentation. I thank you and ask that you invite Professor Alfredo Crossato to the podium.
I thank Professor Bjorge. I now give the floor to Professor Alfredo Crossato.
Thank you, Mr. President, members of the Court. It is an honor to appear before you on behalf of Jordan. I shall now focus on Israel's obligations concerning humanitarian relief in Gaza. These arise from a variety of sources that include the law of occupation, human rights law, the law on the protection of persons in the event of disasters, and this Court's orders on provisional measures. All told, international law requires Israel to provide humanitarian relief to the civilian population of Gaza, a territory which is at present far from adequately supplied. Indeed, a humanitarian catastrophe is already unfolding, where Israel is unable or unwilling to fulfill its duties. It must facilitate relief schemes undertaken by third parties. Time is of the essence, and Israel must do so swiftly and in cooperation with the third parties involved in good faith. Let me start with the law of occupation and two general remarks. First, the Court recently reaffirmed that the law of occupation applies to the entire Palestinian territory, including Gaza. That situation has not changed, and any contention that Israel does not currently occupy Gaza must be rejected. Israel has not been liberated from its obligations as an occupying power. Second, the scope of Israel's claimed authority as an occupying power. Whatever the situation, international law does not confer such an authority or discretion, allowing a state to circumvent obligations aimed at ensuring the survival of a civilian population. It is impossible to conceive a good faith interpretation.
I'm sorry to interrupt you,
Yep.
but could you speak more slowly?
Sure.
Thank you very much.
It is impossible to conceive a good faith interpretation of the law of occupation consistent with its object and purpose that would result in widespread suffering of civilians and destruction of civilian objects. The Court has determined that Israel's occupation is illegal. Its policies and practices, I quote, manifest an intention to create a permanent and irreversible Israeli presence in the OPT, breaching the provision of acquisition of territory by force and the principle of self-determination. You also found that Israel has engaged in a sustained abuse of its position as an occupying power. Any territorial control still exercised by Israel until it has withdrawn must therefore ensure the well-being of Palestinians and respect for the right to self-determination. Moreover, since Israel has been abusing the law of occupation, it cannot claim broad rights or powers arising from it. This is a core legal consequence of the general principle prohibiting the abuse of rights. Israel's relevant obligations are primarily found in the Fourth Geneva Convention and customary international law. As long as Israel occupies Gaza, the customary rule reflected in Article 43 of the Hague Regulations requires it to act for the benefit of the local population. This is a general guiding principle and fundamental duty of Israel. Article 55 of the Fourth Geneva Convention requires Israel, to the fullest extent of the means available to it, to ensure the food and medical supplies of the population, including by bringing in the necessary foodstuffs, medical stores and other articles, if the resources of the occupied territory are inadequate. Article 69 of Additional Protocol 1, which reflects custom, expands the range of supplies that must be provided. Under Article 56, Israel must ensure and maintain the medical and hospital establishments and services, public health and hygiene, and allow medical personnel of all categories to carry out their duties. Article 50 mandates the facilitation of the proper working of all institutions devoted to the care and education of children. The Convention also contains key provisions concerning third parties when the occupying power does not or cannot fulfill the obligations I just mentioned. Where Israel fails to act, civilians are not left to their own fate without more. Article 59 stipulates that if the occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the population and shall facilitate them by all the means at its disposal. Such schemes may be undertaken by states or by impartial humanitarian organizations, and shall consist in particular of the provision of consignments of foodstuffs, medical supplies, and clothing. These are erga omnes obligations of both result and conduct. Israel cannot oppose those relief schemes. Agreement is the required outcome, no exception. Israel must also facilitate those schemes using all available means. This is a high standard of conduct consistent with the gravity of the situation that Article 59 addresses, prohibiting Israel from actions or omissions that may hinder humanitarian relief. Article 59 must be read together with Article 1, which contains states undertaking to respect and to ensure respect for the Convention in all circumstances. Every state party must ensure compliance by Israel with its obligations, while respecting, of course, other rules of international law. Article 59 is a form of application of Article 1, a means for states to ensure...
Excuse me to interrupt you. Please, speak more slowly.
A means for states to ensure compliance with Israel's relief obligations. When states seek to provide relief schemes, individually or jointly, they do not do so only by virtue of an option envisaged by Article 59, they have an obligation to act of their own. Article 59 may require practical arrangements for the orderly supply of humanitarian relief. Insofar as these are needed, Israel must consider them in good faith, bearing in mind the needs of civilians. Arbitrary or unjustified delays would not be consistent with Article 59. They would defeat the purpose of the obligation. In the present circumstances, Jordan, like virtually all participants, considers that Gaza is inadequately supplied. This is manifest, and that Israel's obligations have been triggered. Jordan is also of the firm view that UNRWA meets the principles of impartiality and neutrality, as confirmed recently by the Colonna report and the OIOS investigations. Furthermore, there is no other actor that could realistically replace the agency and its mandate to provide and distribute humanitarian relief and other services in Gaza. Israel must therefore allow UNRWA to continue its humanitarian operations and cease all conduct which prevents the agency from doing so. There is no other way to give full effect to Article 59 of the Convention in the circumstances. Israel's obligations, as we noted, also arise from other sources. These are separate obligations which complement and are as stringent as the law of occupation. I will address a few key ones. Israel must ensure the right to life of Palestinians consistent with the ICCPR and the Convention on the Rights of the Child, which apply in Gaza. This includes a positive duty to take action to prevent foreseeable harm or injury that may result in arbitrary deprivation of life. In the present context, such risk is not only foreseeable, but already materializing. To avoid further loss of life, Israel must strictly respect the fundamental principles of IHL and facilitate humanitarian relief in Gaza. The Covenant on Economic, Social and Cultural Rights requires Israel to ensure the right to an adequate standard of living, the right to the highest attainable standard of physical and mental health, and the right to education. These rights are at risk of being altogether denied to Palestinians in Gaza, and Israel must take immediate action and allow the supply of relief to prevent such denial. Jordan has also referred to the law on the protection of persons in the event of disasters, recently codified by the ILC. The obligations in this area are closely linked to those under human rights law and require Israel, among others, to cooperate in good faith with third parties, to facilitate humanitarian assistance, and not to arbitrarily withhold consent to such assistance. Finally, Israel has obligations arising from the interim measures in the South Africa-Israel case. It must take all necessary and effective measures to enable the unhindered provision of basic services and humanitarian assistance in Gaza. It must do so as a matter of urgency, without delay, and in cooperation with the United Nations. The obligations we have addressed should be interpreted and applied in a systemic manner and against the background of the principle of self-determination, which is of paramount importance. Time, again, is of the essence, and Israel must perform its duties swiftly and in good faith. The horror that Palestinian civilians are undergoing in Gaza must stop. Mr. President, members of the court, this concludes my presentation and Jordan's oral submissions. We thank you for your kind attention in these important proceedings.